Okay, Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome everyone, and good evening, and Sanbonani. I think we've got a very wide-ranging audience here of Muslims and people from other faith groups, and this is really wonderful to have all of you tonight. Tonight's going to be a very interesting discussion from very able advisors and commentators and counselors. Actually, we have Advocate Sheikh Dr. Muneer Abderauf, and we have Sister Refqah Fataar, accomplished people. And just to give you a brief overview of the program, we're going to be discussing a little bit about estate planning, death without a will, pitfalls to avoid, something about estate duty. Somebody have asked about usufructs. Somebody has also asked about multiple marriages, adoptions, the issue about executors, the issue about trusts and Waqfs. So there's really a very, very wide range of topics that are going to be covered, and hopefully we will have time, sufficient time for Q&A. A number of people have actually also submitted questions regarding certain cases, and I think that would really need a lot more in-depth discussion, and hopefully our esteemed presenters here tonight would be able to give us further feedback on some of those questions. So our program lineup would be where we have Sheikh Muneer first, giving us a 25-minute input. Thereafter, we'll have input from Sister Refqah. She would give us a 25-minute input. Thereafter, we'll have a Q&A, and with that, we will start rounding up the whole discussion. So over to Sheikh Muneer.
Yes, Shukran, Brother Zeinoul. My presentation this evening, or input this evening, with regard to the subject matter of Islamic wills, will be what should be in an Islamic will, right? As far as the requirements in terms of Sharia is concerned. So I'll be starting by looking at a person, by way of an example, who passes away with an estate worth 1 million rand. Some of us might think a million rand is a lot, but many of us who might have some property or a house would see that the value of that house is at least 1 million rand in most areas. So if that person were to pass away, what are the various claims or matters that must be seen to in terms of Islamic law as far as his or her estate is concerned? So that 1 million rand, we could refer to it as the gross estate, right? The estate of the person prior to any deductions, right? So the person has the house, whatever it might be, money in the bank account, it might be clothes, the value of the clothes, the books, the laptop, the computer. And adding up all of this, it gives us an amount of 1 million rand, which we could refer to as the gross estate. Now, the first thing that must be ensured once a person dies is that your liabilities must be deducted from that estate as a first claim. Right? Right on top, we would look at the janaza expenses or the funeral costs. So we must ensure that in our wills, that when we pass away, we are instructing our executor to take the available monies that you have left behind and firstly ensure that you are properly buried in terms of Islamic law. Part of liabilities also require that we should see to our religious debts. And this is something that many of us might be oblivious about, especially in terms of the Shafi'i school of law. So if you follow the Shafi'i school of thought or law, you will see that religious liabilities are a requirement and deducted as a first or fourth part of this first class of claims against the estate under the liabilities in terms of Islamic law. So let's say, for example, you pass away and you have not performed a Hajj. You have made the request, the application via Sawuk, you've paid the registration fee, you have enough money in the bank, you are by the means physically, financially, and all of that, but you have not yet been accredited. Right? Then something happens. You pass away. Could be a car accident, could be a heart attack, whatever the instance might be. Now, you are then required to make sure that once you pass away, that your executor is in a position to see that someone performs a badal Hajj on your behalf once you have passed away. So someone that had already performed the Hajj would then perform the Hajj on your behalf. So you must ensure that such a clause is in your will, stating that my executor must ensure that all my religious liabilities, an example would now be the Hajj or the badal Hajj, must be dealt with. Right? Also concerning the administration cost and all of that. From Islamic perspective, we're also looking at the debt owed to your creditors. As the Prophet ﷺ, in the beginning of Islam, when he entered a mosque for a janazah proceeding, for a funeral proceeding, he would ask the question, أَعَلَيْهِ الدَّيْنِ, the person that is laying over here, does he have any debt? Does he have any creditors? If the answer was to the affirmative, the Prophet Muhammad ﷺ would then turn around and he would say, صَلُّوا عَلَى صَاحِبِكُمْ, you make salah on this person, make salah on this companion. Which shows us that even though the janazah salah is a communal obligation, it is a fardu kifaya. Someone has to do it. But the Prophet ﷺ was making a statement in this regard. So we must ensure that all our creditors are seen to once we pass away. By Quranic injunction, we find that the longest verse in the Quran refers to commercial transactions or credit transactions, and where it's stated that it must be reduced to writing, and they speak about 2 witnesses and all of those things. At the same time, if that was not done, it must be dealt with in terms of the will. And we all know that the hadith that plays so much on the radio station, where it says, do not let 2 nights pass, and you have a wasiyah to make, and that should be beneath your pillow. That hadith actually refers to if you have not entered into an agreement in writing with witnesses and so forth. It might just be when you pass away that your creditors will not be given their rightful due. And in order to avoid that, you put that document beneath your pillow, stating that if I were to pass away this evening, which is possible, that my executor or my family must ensure that my creditors referred to on this document and my signature penned here too must be sorted out. Right, so this is very important as far as liabilities is concerned, and this could be incorporated into the Islamic will by stating very expressly that I instruct my executor of my estate to ensure that all my religious liabilities are sorted out in terms of Islamic law. And so once that amounts are deducted, which would also include the administration costs to administer the estate or to wind up the estate, is deducted as the first group of claims. We then sit with the remainder, which is now what we could refer to as the net estate. Right. So the gross estate minus the liabilities in the various forms, we're sitting with a net estate. Now, let's say those liabilities in total was 100,000 Rand. So the person was, he died with a gross estate of R1 million. We deducted the 100,000 Rand, and we're sitting with a net estate of 900,000 Rand. Now, from the 900,000 Rand, we have to deduct the wasiyah claims. Right? The wasiyah is a one terminology we should understand in terms of Islamic wills, And the next terminology we'll look at a bit later on is what we refer to as the mirath claims. So after liability claims, secondly, we deduct the wasiyah claims. And lastly, we will look at the mirath claims. Now, under the wasiyah claims, we find that there are certain restrictions. All right. So you can bequeath as a wasiyah up to a maximum of 1/3 of the net estate in favor of any person or institution, for example, or any person that is not a mirath recipient. Right? So you can't inherit in two capacities. You can't inherit from the wasiyah claims as well as the mirath claims. That is the general rule. The exception would be where the mirath recipients actually consent to the wasiyah claim in your favor. Right? But we'll discuss what is meant by all of what I was saying now. All right. So now we're sitting with 900,000 Rand. And you are allowed to, for example, bequeath that 100,000 Rand, 200,000 Rand, up to a maximum of 300,000 Rand in this example, because the net estate is 900,000 Rand, 1/3 would be 300,000 Rand maximum, in favor of any person who does not inherit from the mirath claims. For example, your father, your mother, your son, your daughter, or your surviving spouse. Right? So this is very important as well, because once the wasiyah has been dealt with, the mirath is basically distributed in terms of what Allah subhanahu wa ta'ala had ordained in the Quran. In Surah An-Nisa, in chapter 4, verses number 11, 12, and 176. Right, so it might just be there are a number of problematic areas. Let's say, for example, you have a child that was conceived out of wedlock, and that is one of the questions that we've been asked. Does that child inherit, right, in terms of Islamic law? Then we have to distinguish between the wasiyah claims, or wasiyah estate, and the mirath estate. The child conceived out of wedlock could inherit from the wasiyah estate, but not necessarily from the mirath estate. So let's give a bit of context to this matter as well. Firstly, does a child out of wedlock inherit? Now, the answer is not very simple. If you look at the position of a child as far as inheriting from his or her mother, the simple answer is yes. That child inherits from his or her mother. Whether or not the child was conceived in wedlock, born in wedlock, conceived out of wedlock, or born out of wedlock, all those examples or instances, that child will definitely inherit from his or her mother. There is no disqualification as far as that is concerned. However, the position of that child inheriting from his or her father is a bit of a problem. If the mother and the father were married in terms of Sharia, in terms of Islamic law, at the time when the child was conceived, then definitely that child would inherit from both. The mother, we say definitely, but as far as the father is concerned, the child will also inherit from the father, because that child was conceived in wedlock as well as born in wedlock. However, it does become a bit of a problem if that child has been conceived out of wedlock, where the child, where the parents of that child, or the biological parents of the child, were not married to each other at the time when the child was conceived. Now, in that instance, as far as the father is concerned, if those biological parents married each other and the child was born 6 months or more after the nikah, there is a rebuttable presumption that the child was conceived in wedlock, and that child will be deemed to be the legal or the lawful parent of that father as well, as long as the birth took place more, or 6 months or more, after the actual nikah. in this regard. However, it is also possible that parties decide not to marry each other, or they only marry each other maybe many months after the pregnancy. And in that instance, when the parties marry each other, the child could be born within 1 month or even 2 months after the nikah. And in that instance, the child would be disqualified from inheriting from the father's estate. Now, in that instance, we now have to distinguish between the mirath estate and the wasiya estate. That specific child would be entitled to inherit from the wasiya estate, which is now that 900,000 rand, up to a maximum of 1/3 of that estate, if the father decides to make a wasiya in favor of that child. Right, so in this instance, he could then decide to bequeath to that child 1/3 of the estate, which is 300,000 rand in this example. He could also decide then to bequeath the same share as the other sons would inherit in terms of Islamic law. Right? It could be more, it could be less. But what we're stating now is that there is a possibility, but it is not automatic that a child will inherit. And therefore, if you're drafting your Islamic will, you could ensure that the child inherits from the wasiya estate. All right, the same would apply with regard to an adopted child where you have decided to take on. Bear in mind, in terms of Islamic law, that child is nonetheless entitled to inherit from the biological father, even though lawfully they say there is no time. All right, so keep that in mind. Okay, that is enough said concerning the wasiya as far as adopted children and children conceived out of wedlock. That wasiya can also be given to any other individual or institution who do not inherit as mirath beneficiaries. All right, so you can give it to, let's say, Awqaf South Africa, you give it to Sons of, you can give it to the local masjid, you give it to your neighbor, as long as those persons are not your compulsory or your mirath beneficiaries. So let's say in this instance, they have then bequeathed, or you have decided in your Islamic will to bequeath that one maximum of 1/3, dividing it in two halves, so 1/6 in favor of the local masjid and 1/6 in favor of your ex-wife, right? For example, right? That's allowed because you're no longer married to her. There's no mirath tie of that ex-wife to your estate, so you could do so. In this example, we're now sitting with a remainder of 600,000 rand. Now, when looking at the mirath estate, that is now the final part of your will, or the mirath clause of your will. There are two ways to deal with this. The first way would be to look at what the Sharia says, who your lawful beneficiaries are in terms of Islamic law. So let's say, for example, when at this current point in time, you might have a mother who is alive, you might have a father that is alive, a son who is alive, and a daughter who is alive, and you might have a widow who is alive. Now, all of these persons are your compulsory beneficiaries, right? They refer to as the mirath beneficiaries, and they inherit in terms of the Quranic injunction. Verse number 11, 12, and 176 of Surah An-Nisa, which are the primary verses of inheritance. All right. I see I have 5 minutes left. So basically, the one way to deal with the matter is to work out what the shares are in terms of Islamic law and to draft those clauses into the will. Right? That is the one way of doing it. The possible problem that could arise here is if the situation changes. Let's say you have one son when you drafted the will initially, but later on you have another son. It would then mean that the second son is not catered for in terms of the will. Right? Same with divorce and your parents passing away, there might be certain consequences because of the developments, and it might be the consequences in terms of Islamic law is not necessarily the same consequences in terms of South African law. The second possibility would be where the person actually says in the will that I then leave my estate in terms of Islamic law. And for purposes of dealing with this, my executor should then approach an Islamic institution like the Muslim Judicial Council SA, and they should then issue an Islamic distribution certificate stating who my lawful heirs are at the time of my death. Right, and in that instance, you will find that even though the situation might change, that nonetheless, the certificate will be issued based on the facts that were applicable at the time of you passing on. Right, so in both instances there, you will find that your estate, as far as the liability claims are concerned, that must be Sharia compliant. As far as the mirath claims are concerned, that should be Sharia compliant. And as far as the wasiya claims are concerned, that should also be Sharia compliant. And by doing that, then when you pass away, then you'll find that you can worry about the bigger things as whatever the questions in the grave, what that is about. And rest assured that your executor that you have approached or nominated in your will then deal with your will based on freedom of testation, as you have stated what should happen over there, and it will be in terms of Islamic law. All right, I think that was the time allowed for me for my input on the subject matter, and I hand you back to Brother Zeinoul Abedien. Shukran.
Jazakallah khair, Sheikh Muneer, Dr. Muneer, Advocate Muneer. So, alhamdulillah, Jazakallah khair for that. Brothers and sisters, listeners, viewers out there, I think Sheikh Muneer has covered quite a few items regarding the Islamic world: janaza expenses, religious debts, debts to creditors, the wasiya. He elaborated on the issue of children born out of wedlock. Then, of course, he discussed the issue about mirath beneficiaries, which are the faraid, compulsory Quranic beneficiaries. So with that, I just would like to also mention that Sheikh Muneer has written a number of articles. He's published very many chapters in books. He's got lots of publications under his belt, and really, I think we really have somebody who's really well versed on the issue of Islamic inheritance. With those few words, I think we're going to go into the next speaker, who is Refqah Fataar, Ho-Yee. Refqah is an Exco and Remco director at the national law firm STBB, that's Smith Tabata Buchanan Boys. She manages the Claremont branch in Cape Town southern suburbs. After 10 years of successful practice as Refqah Fataar attorneys, she also merged her firm with STBB in 2008. She is the national head of STBB's Wills, Estates, Trust and Curatorships Department, and also specializes in conveyancing and all aspects of property law. So I think we're going to be listening to her for the next 25 minutes. Her inputs will also cover some of the pitfalls that we need to avoid in drawing up wills, and also some of the issues regarding, from a legal perspective, South African legal perspective, on drafting our wills. Jazakallah. Over to you, Sister Refqah.
Assalamu alaikum, everybody. Thank you, Uncle Zeinoul. I'm so excited to be chatting to you, and there's so much I want to share with you. And thank you to all the viewers for all your questions that you've sent through. It's helped me to just kind of limit what I'm going to be saying tonight to what you're specifically interested in. And so I'm going to try and answer as many of those questions as far as possible as I'm speaking. And then if you've got any questions, do pop them in the chat. And after this, we also have a nice Q&A session, and between Sheikh Muneer and I will answer as many questions as we can. And then inshallah, the ones we don't get to, we'll just submit the answers, and that will be posted on the events page. And so when we're drafting our Sharia compliant wills, it's so important as South African residents to understand that we fall within the context of the South African legal system. And when it comes to wills and estate planning, and then estate administration after we pass away, we need to look at a number of different acts and regulations whilst we're still trying to make sure that we've got Sharia compliant wills. And so one of the first questions that people always ask is, why would I need you, Refqah, to draft my will? Why can't I draft it myself? And I think that the fact that we get so many questions at these kind of seminars and workshops just speaks to the fact that a will is certainly not a simple document. It's the only document that's going to govern what happens to all of the assets and your debts that you've accumulated over your lifetime. And also, it's got to deal with your legacy, and it's got to deal with Sharia compliance, and you also want to make sure that your family is taken care of. So all of that responsibility is only in this one document. And so I think, certainly from my point of view as an attorney, I think you should certainly get advice and have someone draft it who is knowledgeable. And if you're drafting it yourself, have someone look at it, because the last thing you want to do is leave an incomplete, a potentially invalid, and also a very impractical will. And in the short space of time that I've got this evening, I want to spend time on the practicalities of our wills. So to paint the picture, imagine the scenario, which is quite common. We've got mom and dad who were married Islamically, but they also married in community of property. And that's still the case for lots of our older generation, maybe even people my age. They find themselves married in community of property, but also married by nikah. And so that's a good starting point, because when you're drafting your will, you need to understand what marital regime you fall into. So, for example, if you're sitting down with your parents and they're married in community of property, or you're taking them to an attorney, understand that dad's will is going to govern half of what he owns, because he's married in terms of South African law in community of property. So he actually only owns half of the property. So dad's will legally can only deal with half of the property, not the full property that he might think he's dealing with. And similarly too, if he's a member, the sole member of a CC, for example, and he runs the family business, he actually only owns half of that membership of the CC. You know, mom actually owns the other half, even if she's got absolutely nothing to do with the day-to-day running of it. So just think of those sort of things when you're busy with properties. And as we go through this, also just think about your own marital status. And as we go through it, I'm going to chat about costs as well. And another thing people often ask is, should I have a single will or a joint will? And a joint will is just one will that is signed by two parties. Let's use mom and dad as the example. So irrespective of how people are married, in community of property, out of community of property, married Islamically only, some couples have a joint will. What that means is that there's one will that you either have mirrored your intentions, so or you can have completely separate clauses. For example, dad's going to have his Islamic heirs, mom's going to have her Islamic heirs. They might have completely separate wishes in their wasiyat portions of that 1/3, but yet they've reflected it in one joint estate. One joint will. I do recommend a joint will if your wishes are quite mirrored and they're almost identical. But when you've got very specific clauses, especially something like the wasiyat, which is where freedom of testation comes in, and you can do with your 1/3 what you want to, I do recommend then that we have single wills for each party if they become too different, the terms in the will. If you've got a joint will, what practically happens is, let's say dad passes away first, the joint will is lodged with the master's office together with all the other reporting documents, and the master of the High Court is where all deceased estates are reported, and each milestone that we complete as executors, that then gets submitted to the master, and the master then gives us the go-ahead to go on with step 2 and 3 and so on. So that joint will is lodged with the master's office, and if mom, who is the surviving spouse, does not subsequently draft a new will in years to come or down the line, when she passes away, that joint will, that original joint will that's lodged at the master's office, is her will. It's still her will because she hasn't updated it. So when mom passes away, we then report her estate to the master's office, but we then state in the cover letter that mom was a signatory to the joint will in dad's estate, and we give the master dad's estate number and a copy of the joint will if we've got it, and then mom's estate is administered according to that same joint will that was lodged years ago maybe. So, but of course with everybody, whether you have a joint will or a single will, I always recommend that you update your will when different milestones in your life take place, when someone passes away, when there's another child, when you've immigrated, and we'll chat about foreign wills in a minute, you know, when you get divorced, or when circumstances change, and when there are financial circumstances, maybe you've sold your business, you've closed down shop, and you're retired, and you want to look at your will because you might have put certain bequests or even your wasiyat that you might not be able to financially be able to achieve or comply with now that you're retired, and you've maybe traveled or you've spent money, or post-COVID people went through quite a bit of financial strain with their businesses, but yet you've left these bequests, which is what the wasiyat clauses are. They're special bequests that you're leaving to certain people, but you might not be able to afford that now a year or two later, so you'd want to look at that again. People also ask me about executors. So of course, I, as an attorney, I act as executor on hundreds of wills, and if I refer to the word executrix, it's just the female term for executor. Anyone can be nominated in your will as executor. Of course, it should be a major, not a minor person, and I think the one thing I want to leave you with is, whilst a lot of people nominate their surviving spouses or one of their children as executors, it's not only an administratively intensive role. You also need to liaise with so many government departments all the time. You've got to deal with SARS, the deeds office, the master's office, every institution that your parent dealt with. So, you know, if you've got bank accounts at various institutions, you've got investments at various institutions, you've got all sorts of accounts, or even just subscriptions, you know, that executor is going to have to literally step into your shoes and close off all of those things and engage with them. So it's got to be someone who's at least going to be savvy to be able to speak to all of these institutions. When you are the executor, just note that at the moment, SARS wants the executor's personal e-filing login profile linked to your role as executor. So, for example, I get SMS'd by SARS all the time because I've got hundreds of estates that I administer under my name, and so SARS links all of those to my personal profile. So if you've got a nominated executor who is maybe a housewife, for example, who's not au fait with SARS, or isn't even a registered taxpayer, that's going to be problematic. Having said that, if you are appointed as executor and you don't have a clue what to do, or you're not interested, or you're not familiar with anything, an executor can certainly sign a special power of attorney and grant someone like myself authority to step into your shoes as executor and administer the estate, which is what we do all the time, because most wills, quite a few people nominate their surviving spouses or a child, or someone who's just not capable of or practically able to take care of the estate administration. So we do that. I then get asked, well, what happens if my child acts as executor? Can she also be an heir? There's no prohibition or any limitation to your rights as an heir when it comes to being executor. The only limitation is when you act as a witness. So I don't recommend that anyone who's going to be either a wasiat heir or a residuary heir acts as and signs as a witness, neither to the spouse of such a person. And so I had a client who passed away, and his daughter's husband had witnessed, but years ago, back in the day when they were just dating. And then, of course, subsequent to that, they got married, and it just adds to complications, because in terms of the Wills Act, there are limitations. And so what the limitations are, just very quickly, are if you are nominated as an heir in someone's will, but you also witnessed, in terms of South African law, and then we always have to go back to South African law. In terms of South African law, if you witness a will in which you are an heir, your inheritance will automatically be limited in terms of South African law to what you would have inherited if your parent had died without a will. And so that means you would then inherit in terms of your intestate succession share. So let me give you an example. If you are inheriting from your dad and you're entitled as an Islamic heir to 30% of his estate as an heir, but you've witnessed the will. And in terms of intestate succession, there are certain thresholds and shares that go to intestate heirs. And so in terms of intestate succession, in terms of South African law, if you had inherited from your dad, if he hadn't had a will, you might have only inherited, say, 15%. So in terms of South African law, your 30% is now limited to 15%. What that means is that when we attend to the estate administration, you know, and your family knows that they want you to get your Islamic share. But practically on paper, in terms of what we're administering, we won't be able to give you more than that as far as the master's office is concerned. So we'll have to go through the estate administration process and document on the liquidation and distribution account that you're only getting the 15%, because the master will not allow you to get any more than that. That 15% is recorded. That's what you get paid out on distribution by ourselves as executors, and then between your siblings, you're going to have to do the redistribution. Well, we'll help you do that, but we do the redistribution so that you end up getting the share you were supposed to get. The problem with that, as you can imagine, is you have to have buy-in and agreement from the heirs, because there's always someone, and there's always, you've got those family members. I deal with those families all the time. As soon as there's an opportunity for dispute, there will be a dispute. And so you want to ensure that your will is not only practical, but carefully thought out and well worded, so that we avoid, these kinds of disputes. As soon as there's an opportunity for a dispute, I promise you, someone's going to be unhappy. Someone's going to not agree to something. And when it comes to wills and redistribution of assets and inheritance, you're going to need 100% agreement by all the heirs. It's not a case of, 80% have to agree to something. So, on that, when it comes to redistribution, I'm going to want to chat about the property in an estate, especially the family home, in a minute. But while we were chatting about executors, people also ask about costs. And so the executor's fee is based on a statutory tariff, which is 3.5% of the gross asset value. So that would be my fee if I'm administering the estate. But of course, it's negotiable just based on the amount of work involved. And often people will start out and say, oh, it's just a simple estate. And it's never a simple estate. No matter how big or small an estate, you still have to go through, all the steps if your estate's worth more than 250,000 Rand, which most people's estates are. You have to run the full gambit of the whole estate administration process. And at the moment, that's taking about 18 to 24 months, unfortunately, because we're linked to so many institutions. We've got to deal with, as I said, banks, investment houses, insurance companies, SARS, the deeds office, the master's office, and so on. One of the expenses is, of course, the master's office fee. It's not a huge amount depending on the value of your estate. If you've got a small estate that's under 400,000 Rand, you would then pay only a 600 Rand master's fee. That escalates based on the value of the estate up to a maximum of 7,000 Rand. So 7,000 Rand sort of covers a 3.6 million Rand estate. And above that, you're going to end up paying a 7,000 Rand master's fee. Then, of course, you've got, as I said, the executor's fee. If you've nominated a surviving spouse or a child as an executor and you haven't put in wording because you've drafted this will yourself, or you've asked someone to draft the will who isn't familiar or competent in drafting a will, and they haven't put in the security clauses. So you might have seen those wills where you say my executor is exempt from furnishing security. The security referred to is a bond of security. It's an insurance policy to say that the executor is not going to go all dodgy and run away with funds, and you and I know that happens, unfortunately. So when you nominate a surviving spouse or child as executor, they are automatically exempt from providing security, but you've still got to take care to put that clause in that your executor is doesn't have to provide security, is exempt from it, because you need to understand that if that clause is not in and your nominated executor has to obtain security, a lay person cannot obtain a bond of security in this country. Bonds of security are only issued to attorneys and maybe other professionals like accountants, but certainly ourselves as attorneys. So I end up by default acting as executor or executrix because there wasn't a clause exempting the executor from furnishing security. Someone has to obtain a bond of security, and that means I have to step in. A bond of security is an unnecessary expense for an estate, so make sure your will does have that clause in it, or contact us if you need us to look at it, because a bond of security costs 0.5% of the gross asset value per annum as a premium. So, and that's paid by the estate. People also ask who pays all the costs involved, all these costs that I'm going to speak about today and that I'm already speaking about, who pays those costs? The estate covers the costs. So when it comes to, and so you can see on the screen, we've got some of the costs associated, and we'll go through those now. When you're dealing with any of these expenses and when you're planning, so I want you to think about, after this, think about what you own and think about what you owe. And is there sufficient cash liquidity in your estate, whether it's available cash or assets that would need to be sold, or life insurance, or any other investments that your executor could tap into that you have access to, or that you've made provision for after your death to cover your debts? As Sheikh Muneer says, we have to make sure that we're settling our debts before we can, of course, advance funds to our wasiat heirs in terms of the bequests, and then of course to our residuary heirs who are expecting to get inheritance free of debt. And unfortunately, what happens in the real world is that on a weekly basis, I have to sit across from families and explain that yes, your dad ran a successful business, but unfortunately taxes weren't taken care of, and we'll chat about taxes in a minute. Or yes, your dad, provided and paid off and was paying the bond monthly, but now he's no longer around, and there's no one left to service that bond monthly. And unfortunately, since the Consumer Protection Act's been around, life insurance is no longer a legal requirement when you register a bond. And the immediate impact of that I saw as a conveyancer dealing with bonds and properties is that when you don't make something compulsory on a South African, like forced savings and forcing someone to have a bond, the older properties where people had bonds in the old days, they've all got life insurance. But the more recent, in the last certainly 15 years or so, if you give people an option, they're not going to take out life insurance. So take out life insurance. Make sure that you've got provision to not only settle your debt, but that you've got provision that there's still money in the kitty, so that you're leaving your home to your family, but have you made provision as to who's going to have the money to pay the rates and services every month, and basic things like that, and the insurance. So more and more we're dealing with estates where there is no life cover. So imagine your family is inheriting your home, but they now have to service the debt. What happens with that when it comes to, that's the under bond costs. So let's say mom and dad, they're married in community of property. So mom owns 50% of the property, dad owns 50% of the property, dad passes away, there's a bond on the property. That bond, like every debt has to be settled and taken off the name of the deceased so that we can finalize the estate. And what that means is that when it comes to a mortgage bond, the bond is in the name of whoever owns the property. So mom and dad own the property, then the bond will be on mom and dad's names as the mortgagors. And that means that when dad passes away, the banks and the master's office will want us as executors to remove dad's name from that bond or cancel the bond. Now, if you've got a strictly Sharia compliant will, you've got that one-liner will, which I personally don't like, and I'll explain why, because it doesn't make provision for all the possible scenarios that we could put into play when it comes to an estate, and we'll chat about that now. So your estate just says, I want my entire estate left to my Islamic heirs. What that means is every asset has just been left to all of your Islamic heirs. So they're all going to share in the property, and they're all going to share in the business, and they're all going to share in the cash that's left over after you've paid debt. So let's talk about the property for a second. So mom and 3 kids are inheriting this house. Mom might not be working, one of the children might be working. So 4 people are going to inherit the house, but remember, that's half the house. Mom already owns the other half of the house, but dad was the one who actually paid off the bond. So you've got a number of options here. The worst option is, of course, to sell the property. So we're trying to always keep the property for the family, unless we're really in a sticky financial predicament and we have to have those terrible conversations. If the family wants to keep the property, but there's a bond that still needs to be paid, and there's no life cover, and there's insufficient cash to cover that, we have to then look at the parties who are going to own the property and see if any of them are able to take over the debt. And we'll chat about if any of those are minor heirs in a second. Let's just assume mom and the children are all over the age of 18, and maybe 1 or 2 of them are working, and they would qualify to take over dad's share of the debt, because mom's share of the debt, mom still got 50% of the bond, right? Is her responsibility. So let's say the 2 children qualify to take over the debt. We then apply for a substitution of debtor. We don't cancel the bond. So chat to me if you need that kind of assistance, because it's a cheaper, quicker process where we then get the banks to look at the creditworthiness of the children to see if they can qualify to take over the property, the loan. And then we don't have to cancel the bond, because to cancel the bond, whether there's a settlement figure there or not, even if it's a null bond, it's going to cost 6,000 rand just to cancel your bond. And then you're going to have to pay to register a new bond. And there's thousands of rands on an initiation fee on a new bond. So you want to try and rather do a substitution of debtor, where we're just substituting the name of dad. So, okay, so we're on 8 o'clock. So I'm rushing through. I've just got a couple of minutes. And then I just wanted to say to you, as we're going to go into the questions, so we've got transfer costs, and people often ask, well, who's going to pay those transfer costs? And is it the heir who's got the most money, or and it all comes down to this pro rata share. So if you've got your heirs who inherited in Islamic shares, then, and if there's a shortfall, if the estate can't cover any of the expenses, it doesn't matter if it's transfer costs or taxes or anything like that, then we have to pro rata the expenses according to the share. So unfortunately, if mom is inheriting 1/8, mom's liable for 1/8 of the shortfall if there's insufficient funds. And then of course mom doesn't have any money because mom's not working. So then we have to look at, are any of the other heirs going to assist mom, and does she owe them? And so I think it's important to have a look at what your debts are when you're doing that kind of estate planning, so we can help you with that. And then very quickly before I cut off and then we carry on to the Q&A session, I want to quickly talk about taxes for a minute if I can. And so there are so many taxes that come into play when you pass away, and I want you to be aware of it and chat to us as attorneys or chat to your accountants. They are you can't hide anything from SARS. So you're going to have all the skeletons in the closet come out. And so if you didn't pay your income tax, all of that's going to have to be paid. SARS pretty much audits all estates at the moment. And so you'd have to pay we'd have to pay your arrears from hopefully your cash assets, or assets have to be sold. If there is an exemption when it comes to a primary residence that we're transferring, we can certainly hopefully get away with not paying capital gains tax, but there will be capital gains tax payable. If you've got a second property or you've got shares in a business, we'll have to pay, your estate will pay capital gains tax when we transfer that to heirs. And of course, we'll chat in a minute on estate duty. So we'll get to some of the Q&A, and I'm going to hand over to Uncle Zeinoul, and I'm sure we'll get to some more questions in a bit.
Okay, Jazakallah khair, and Sister Refqah. And by the way, anybody wants to view her PowerPoint, you can view it on the Awqaf South Africa website. So Refqah has actually gone through quite a few issues here: marriage in community of property, marriage by nikah, having single or joint wills, the executor's appointment, very important, whether you're appointing family members or whether you're appointing a lawyer. Then you need to also look at the issues of signing the will. Who signs the will? Is it an heir that signs the will or a non-heir? This could potentially be a pitfall, and it could be detrimental to the heir as well. The cost of the estate administration, the length of time that it takes for the winding up of the estate, I think that's a major issue, and especially nowadays with the performance that we have at government. Then the issue of security that needs to be provided to the estate, to the master rather, the cost of the estate, and very important is the issue of liquidity. Very often, when there's a person that passes away, there isn't sufficient cash even for living expenses. So one needs to ensure that when we're doing estate planning, we also have sufficient cash so that at least the home fires and there's food on the table, the rentals can be paid, the water and electricity can be paid, and so on and so forth. So I think with all those, Jazakallah khair. We'll jump into the Q&A now. There's literally hundreds of questions, and I think we're going to, some of your questions may have been answered in both the sessions, but let's see if we can actually tackle some of them. I think the first one is, what happens when you pass on without a will? And that is a crucial question, and maybe Refqah can answer that in a minute.
Shukran, lovely question. And so the estate process is exactly the same when you pass away with or without a will, with one big exception, which is delay and possible dispute. So remember, as I said when I spoke earlier, we're dealing with the South African legal system, but at the same time, we want our estates administered in terms of Sharia. And now you haven't left that direction in the form of a will. So the default position will always be, unfortunately, the South African legal system. And so you then end up reporting the estate as intestate, meaning without a will. And then if the family wants the estate administered not in terms of the intestate shares of South African law, but in terms of Sharia, then all the heirs would have to agree, and then we just obtain an MJC Islamic distribution certificate. We submit to them. They don't just issue it. We have to give them a set of all the documents we would have given the master's office, which is, the death certificate and everyone's IDs and all of that FICA. And then they issue the MJC distribution certificate, and we lodge that with the master. The master doesn't turn that down at all. We lodge an original, and then they allow us to administer the estate in terms of Islamic law. If the family has not reached agreement, then unfortunately the default is intestate succession. But the estate process is the same. The costs are exactly the same. No costs differ if you die with or without a will.
So what happens? Sorry, can you hear me?
Yes.
Okay, so what happens, just following on that question, if you pass on without a will and you don't have any heirs?
So if you pass away and you don't have heirs, I've actually got one of those now. People always just assume, okay, it goes to the state. So what happens is, when we pass away without a will, in terms of intestate succession, there's a list of our heirs, and that would be children if we've got them, or parents. And if you don't have a spouse or children or parents, it would then go to your siblings in terms of South African law. And if you don't have siblings, you then go further into extended family. If there really is absolutely no extended family, and you have to prove to the master that you've hired a tracing agent, you've gone onto Facebook, there are all sorts of social media that really helps us nowadays to try and find people. But if you don't find someone, then by default the estate devolves upon the state. But we generally end up finding someone, and we have to advertise as well, and then someone does come onto the woodwork to try and claim.
Okay, if I can pass this on to Sheikh Muneer. There are quite a few questions pertaining to trusts. So when people actually create trusts and they transfer their assets into a trust, how will the issue of Islamic inheritance operate there? Assuming they no longer have assets in their own names, but that all the assets are now transferred into a trust. I think you're muted.
All right. So shukran for that question, Brother Zeinoul. Yes, in the event where a person passes away with there's a trust. That trust basically deed or those trust property will be dealt with in terms of the constitution of that trust. So basically everything will be dealt with accordingly. So if before the person passed away, they establish a trust, they put the assets into the trust, and the provisions in the trust will then will guide as to what should happen. As far as Sharia compliance of that is concerned, it would depend what the provisions in the trust is. Therefore, I need to have a bit of more information concerning that.
The issue is in terms of the Sharia Faraid heirs. So should the trust reflect or mirror the Faraid heirs, or can it be, for example, if you have sons and daughters and you create the trust, and in your trust you're saying that all my heirs or my children will inherit equally. So what effectively is happening is that it cuts out, let's say, all other family members, or it would only restrict. For example, if your trust only restricts your personal family, your children, and excludes other members of the family who may have been heirs had you had all your assets in your own name. So I think if you can just elaborate on that.
Yeah, but basically, we're looking at that question. This trust is not something which is akin to Islamic law. There is, however, in terms of Islamic law, there is the Waqf, right? You find the general Waqf, and then you find the family Waqf, or the Waqf Ahli, which are both, it has certain requirements. But based on the question, I see that in order to try to avoid certain taxes, if you're taking the asset, let's say now the father owns a house and he owns a number of houses, he establishes a trust and he then transfers the property into the trust. And he says that at the time of my death, it is then my instruction that that the trustees of the trust mustn't distribute that in terms of my last will and testament, in terms of Sharia law. Then that should not be an issue. Yeah, but if the intention was that yes, it's still my property, I'm putting it in there, but it's still mine, then yes, technically it should be distributed in terms of the laws of inheritance as part of his property. But if his intention was, let's say, you want to establish a waqf or whatever, a general waqf for the public good or for the family, then those consequences would then find application. So it depends on the clauses in the actual trust deed.
Okay, here's a question by Hasina, also to you, Sheikh. Say we've spent funds on or expenses taking care of parents. So certain children may have spent a lot more on taking care of parents. And the person asks, can a person claim for expenses incurred while taking care of parents from a parent's estate?
Shukran for that question. That's a very general question that normally applies where you're sitting in the office with a family members who are now recipients of a Sharia will, and the daughter then says that, look here, but I've been looking after my mother for so long, why am I then inheriting half of what my brother is inheriting? So as a daughter, I'm inheriting half of what the son inherits, and I've done A, B, C, and D. Now, with regard to that which she has done during her lifetime or during the lifetime of a parent, it's very important to then state at that point in time, as same with the trust you're looking at, what the provisions in the trust is important, what the intention was, and all of those things. What is it that you are establishing? With regard to that, looking after your parents, it could either be that I've done so with the intention of this being a sadaqah. It's my gift to my parents. I want to do that, and I'm seeking reward from Allah subhanahu wa ta'ala. That is all well and done, and then it's done. And that is separate to inheritance because the reward lies there. Or you could say, look, right now, none of my other siblings are doing this, and I'm doing a favor now here on their behalf as well. But I'm not doing it as a gift, but I'm assisting with as a loan, but it's a non-interest bearing loan. So they don't have to pay me any more back. It's basically just an assistance, qardan hasanan, for example. And in this instance, when the person does pass away, it doesn't only have to be a parent, it could be a sibling and so forth as well. So you're assisting with this money, and when you pass away, you would be one of the recipients of the liabilities. And therefore, when you enter into the transaction, I'm paying for your medical expenses, I'm paying for your groceries and all of these things, then that discussion must take place. And it must be ascertained, what was it? Was it a loan or was it a gift? If it was a gift, then it's over and done with. But if it's a loan, then you'll be entitled to claim back what you are entitled to as a creditor of that estate.
Okay, a quick one, Sister Refqah. Can a beneficiary be appointed as the executor of an estate?
So anyone can be appointed as an executor. So I'm personally nominated as executor in my dad's will, and I'll also be one of his heirs. So yes, I can. As I said, you just shouldn't be the witness.
Okay. Now, maybe this is a very sensitive question. If the executor is not performing and maybe unscrupulous or whatever, for whatever reason, maybe unfair or unjust or in the execution of his or her duties, can an executor be dismissed or recall?
So the quick answer is yes, but it's a process, because the master's office, of course, oversees the entire process. So what happens is it takes a very long time, but you would need to write to the master's office as the heirs, and then mention, what you have to have it detailed, because it's quite a serious claim. So you'd have to have detail and submit that to the master's office. The master will then and I call it the master, but it's obviously a whole office of people that work at the master's office. So at the master's office, the relevant estate controller or assistant master would write to the executor and would let them know and give them a copy of your complaint. And then the executor will have another, 2 weeks to a month to respond. And then the master would send that on to you. So it's sort of like a post office. They just forward the correspondence, and the master doesn't usually make a final decision. You would, as the heirs, probably have to go to an attorney who would eventually write to the master. And so we do get involved when there are cases like that, and then we write to the master and motivate why it's in the best interest of the family and the administration of the estate that this person be replaced. And usually when there's a dispute between family members, or when there's some dodgy executor or someone involved, the master would generally ask the family to obtain an attorney's consent to act and step into the shoes of that person. So we end up doing that.
Okay. Jazakallah for that. We have a growing number of Muslims coming, or Muslims or people reverting to Islam, and we find that many of their family members may not be Muslim. Even children may not be Muslim. So how is that actually treated from a Sharia perspective, Sheikh?
Shukran for that question. Now, I saw the question earlier on the page. Yes, if a person embraces Islam, it might be that the family also embraces Islam, but there's no compulsion in him doing so. As we know, the Sharia says, La ikraha fi din, there's no compulsion in this deen. Now, in that instance, when I discussed how the estate is distributed, we found that the liabilities are first deducted, thereafter the wasiyah, and we restricted that to the 1/3. However, if there are no Islamic law beneficiaries from the mirath sense of it, and everyone is disqualified, that technically should go to the Baytul Mal. The scholars basically have differed in their opinions as to whether or not there is an established Baytul Mal and all of that. And therefore, in that instance, the opinion found in the jurisprudence is that 1/3 is no longer restricted, because there are no mirath beneficiaries. So in that instance, I would advise that the person then follow the opinion that 1/3 is no longer restricted, and he can or she can bequeath the complete 3/3 in favor of the wasiyah beneficiaries. Right, and that would be obviously after checking everywhere: is there a distant uncle or cousin, whatever it might be, something similar to what Refqah is referred to early on with regard to the laws of intestate succession within the South African context.
Okay, I think that's an important clarification, Sheikh. We really have, I think, many questions and many people coming into the fold of Islam that have this particular issue at hand, and I think this really clarifies it quite clearly. Coming to the issue of usufructs. Now, I think that one of the issues that people have is that, for example, I think Refqah, you mentioned earlier, where mum gets 1/8 of the estate, but mum can actually become homeless if the house has to be sold. So how does one actually protect mum through a usufruct? And is this, maybe both of you can interact on this one here from a legal perspective as well as a Sharia perspective?
So when it comes to the legal position, so a usufruct is the second strongest right of ownership. Short of legally owning the property, you have full rights other than, you know, owning the property itself. So it's quite a restriction on ownership so if you're leaving your property to someone subject to a usufruct, you've got to be very mindful that you're actually restricting that right. And are you then leaving them then their true share, because it is a very restrictive right. The usufructuary, it gets a personal right. That usufructuary's right is limited to that person only, and it's limited for a certain period. It's either a usufruct for mom's lifetime, or sometimes the common one is mom has a usufruct in respect of this property until she remarries, and then she's going to have to go and live with her husband. Or it might be for a certain time frame. You could give someone a usufruct, say, for 5 years, whatever. So that's got to be specified in the will. It can't be decided after. And if it only says a usufruct, then the default is it's for mom's lifetime. What it means is mom can actually move in and out of that property and she won't lose the right. And that people often ask, well, mom's moved out and she's gone to live with my sister for the last 5 years. It doesn't matter. She's still got a legal right of usufruct, which is recorded against the title deed. When you have clauses like usufructs and anything where you've got specific things in the will, you need to state who's covering those costs, because a usufructuary has full right of use to that property, meaning that when there is rental income, if there is someone living in the granny flat and mom has a usufruct over the property, mom actually has the right to the rental income. So you have to be very specific and not just say mom has the right of usufruct. You have to say, when I pass away, my wife has the right of usufruct, but when it comes to any rental income, that goes to the owners of the property, the other heirs that I've left the property to. You've also got to specify who pays the rates and services, because that's very contentious and people fight over all sorts of mad things. And so you've got to say, well, mom's got a usufruct, but your mom should not be paying the rates and services. Well, then who's paying the rates and services, and where's the income for that? So you're putting that obligation then on someone else who owns the property, who might not be living there enjoying that water and electricity, but you're putting that obligation on someone else. Or you have to make provision for some cash, and then mom can live there, and you've made provision for the cash for that as well. And a usufruct costs at the moment about 10,000 Rand to register, just so that you know.
Okay. So from a Sharia perspective, Sheikh?
Yes, shukran for that. Yes, from a Sharia perspective, as we stated, when I looked at the devolution of the estate and how the shares are distributed, that would fall under the Wasiya clause. However, within the Islamic context, it might be a bit problematic, because a Wasiya cannot be given to a Mirath beneficiary. And normally, now it would be the wife would be the Mirath beneficiary. However, within the Islamic context, there is something which is referred to as the Umrah, which is now basically usage of the property. And that, however, would fall outside of the will. So if you would want to then ensure that the wife or the husband, whoever the owner of the property is, wants to ensure that the other spouse, in the event of passing on, would be entitled to remain in the property and have usage of the property for the rest of their life, you could make use of the Umrah by stating that while you are alive, registering it against the title deed or on via Conveyancer or via notary public in the deeds office, and that then it's basically given while you are alive, and that doesn't form part of the will. The bare dominion, however, the ownership of the property will then transfer onto will be registered on all the Islamic law beneficiaries, which would include the surviving spouse being either the 1/8 or the 1/4. And but that surviving spouse would then still have, if that person is the recipient of the usufruct or the lifelong usufruct in terms of the Umrah for the rest of his or her life. This, however, would be optional. However, there is sometimes a bit of an issue concerning, as Refqah has mentioned now, about 10,000 Rand for the registration of something of this nature. And that is basically where it becomes a bit problematic.
So just following on that, what if, let's put it this way, that we're talking about a house in question where the spouse, the surviving spouse, will need to be living there when the other spouse has passed on. So is there then a restriction on the sale of that house so that the other beneficiaries will just have to wait it out until mum or dad passes on?
So yes and no. There is a right to mom. Say, let's say the usufruct is there for mom's lifetime. She can waive that when the property needs to be sold. So let's say the property needs to be sold. She is a co-seller because she's actually got a very strong right. So legally, a usufructuary actually signs the agreement of sale as one of the sellers. So she would have to consent to the sale. And in that case, when clients approach us, we then check and make sure that the property they're moving to next, let's say they can't afford this big family house anymore, they're moving to something smaller, they would either have to register a usufruct so that mom is protected, which is actually the only protection, to show us that mom is protected, and then on that basis she would then be able to sign the consent, or she waives her usufruct, or she signs as co-seller, so that the property can be signed, can be sold, and then they buy something smaller and we register a usufruct over that property. But yes, if mom doesn't agree, which she doesn't have to, and then no one can sell the property, and you can't bond a property either where there's a usufruct unless mom waives her right. She can't consent to the bond. The banks won't agree to that. The banks want a waiver. So mom would have to waive her right to the usufruct if one of the children wants to bond the property.
Okay. Jazakallah for that. So here's a question which, again, Sheikh, this type of question keeps coming up. What are the Islamic rulings on gifting or hiba items, gifting hiba items whilst one is still alive? I think it has something to do perhaps also with what you just mentioned about the usufruct or the umrah. So what are the Islamic rulings on gifting items while one is still alive, but yet the gifter or the one who's giving the gifts still keeps these items in their own possession until passing? But it's public knowledge or the family knowledge that these items have been gifted to so-and-so, maybe gifted to the spouse, for example.
Yeah. Now, shukran for that, and that is basically a common question that arises and something which happens. And I take it that you're referring to now movable properties, could be a phone or a laptop or so forth. As long as there was actual transfer of and possession has taken place. So I have a watch, and I gift it to my daughter during my lifetime, and she accepts that gift, and I give it over to her, and she, for example, takes it home or to her room, and then 5 minutes later she comes out and I says, look, I asked the curate, is it okay if I wear the watch? And she says yes. So technically I've gifted the watch to her during her lifetime. She has taken possession of it. She became the owner of it. And now for the next 10 years, I'm wearing the watch. And it's public knowledge. All the family members know that I've given the watch to her. There have been witnesses to that. So when I pass away, all she does is she just claims the watch back in this regard. But what is important to note is that it should actually be a transfer of the asset and possession. It should not be a situation where I say, look, I got this watch, and once I pass away, my daughter is going to get it. So that's a wasiyah. So that is the difference, the small difference between the gift during your lifetime and possession and ownership had taken place. And the other one is that where you are saying that when I pass away, then she will receive this, and this is now the bequest or the wasiyah, and the issue of her benefiting from the bequest, and she's already a mirath beneficiary, is also something which is problematic.
If I could just jump in here, so Sheikh Muneer, do you agree? I mean, as an attorney, I know we love paperwork and I like things documented. So if there is gifting during your lifetime, I certainly recommend to clients that that's recorded so that it just reduces the disputes and the drama when someone passes away, because sometimes everyone might know that was given to that child during your lifetime, and suddenly someone forgets conveniently, and then the drama starts, and then we don't have any proof of that. So do you recommend that clients record those kind of gifts?
Yes, definitely. I would agree with it 100%. And even when I deal with clients, I do exactly the same thing. I have it reviewed to writing and I have them sign it. especially those beneficiaries who might dispute later on and the document is with them. So even though the actual item would have been with the deceased prior to having passed on, with the document, she can just claim it back. So I totally agree with you.
And certainly when it comes to, property also, because there are those family meetings that people famously have, and then, mom and dad will call everyone around and say, you all know that when I pass away, this house must go to so-and-so and or whatever it is. And so, and then we've maybe just got that, that very standard will, which says, the estate should just go to my Islamic heirs. But what I do like clients to do is, if they can, think about in their estate planning, what assets do you have? What can we actually help you to put down in your will so that you can limit the drama and the disputes, and you can actually say, well, I'm still leaving things in my Islamic heirs. I'm leaving things in my Islamic heirs, but I'm going to end up, I'm going to limit things in my Islamic heirs. I'm going to leave things to my Islamic heirs in the shares, but at the same time, I've got business assets that my son's involved with. He's going to get, based on the value, he's getting the business shares, and my daughters are getting the house, and someone else is getting cash. So you still end up with your same Islamic shares, but you're just getting specific assets that make that up. Just to avoid drama, if there is a specific family like that where you actually need to direct them more in a will.
I think we're running out of time now, but I just want to, just following on this one here. So, for example, we're doing the Hiba Umrah with regard to the gift. But now, in the case of a property where we don't want to actually do the actual transfer and do the transfer cost, because once it's done through the will, there won't be any transfer costs there. But if we're doing it outside of the will during our lifetimes, there may be a transfer cost involved there. So if we're documenting this as a donation deed, for example, or a hiba deed, and we stating clearly that this is the use of this property, or the usufruct is going to my spouse during her lifetime until her death, without the actual possession and without the actual transfer of the property. Sheikh?
Yeah, shukran for that. In this instance, as long as what has been documented is confirmed in the will, right, so it's not two different things being stated, then it shouldn't be a problem. But there might be certain implications as far as tax is concerned, and Refqah would be able to, as a conveyancer, discuss more about that. So if there was a document formulated where the person is saying, I'm giving you this as a lifelong usufruct over the property, has been signed and all of this, and is confirmed in the will, then I wouldn't see that to be any problems as far as Sharia is concerned.
Okay. So sometimes, in order to reduce the burden of debt within the estate, there is an issue where, for example, we can create a debt, and sometimes people create debts with the issue of mahar. So the question is, can the mahar be increased after the nikah as a debt to be paid on death?
I think that's for me. Yeah, definitely that can be done as long as it's a true debt. Okay, the scholars they've stated at the time of the nikah, you have that amount that is paid as a mahar mu'ajjal, a deferred dawah, that is all in order. And as far as post-marriage, whether or not to increase the dawah, that the majority of scholars, or many scholars, say that there should not be a problem with that. But the main thing is it should be something real. So you can't say, okay, right, I'm giving you this, increasing the dawah to 2 million rand to create a debt. But then later on, when there is a talaq or a fasq, he says, no, actually, that's not what I meant. It should actually be something real, which means that if that was a true debt now created now due to the mahar or the maskawi or the dawah, then automatically all other legal consequences should follow from that position. Then it shouldn't be a problem.
Okay. Well, anyway, I think we've run out of time, and we've come to the end of this program. But before we close off, I think we really need to say Jazakallah khairan to all the viewers out there, all those people that have registered, and all those that are listening to this program on YouTube and Facebook. Jazakallah khairan. Thank you very much, Bayadanki, Nyabonga, for coming on board and listening to this. And I'm sure it must have been very, very insightful, as it was for me as well. And inshallah, there are many, many questions which I hope that our esteemed guests will take the time to look at them again, and perhaps if we can submit an answer to you by email or so, we try to do that. We can see that there are many, many issues, and there are many, many cases that people have actually asked us to have a look at as well, but unfortunately we don't really have the time for that. We may, as a matter of follow-up, have a further kind of session if it's so warranted, and then we can, inshallah, address many more issues. But one can see that the whole issue of wills and estate planning is so important that people can, the families can be separated. Families, due to squabbles, can have enemies for life, and we see this and we experience this all the time. So in order to have that good relationships with people and family and so forth, it's best to discuss these issues prior to death with the family, sit around the table, have a discussion, clarify what's going to happen to the estate, so that you avoid all those kind of pitfalls. Make sure that the will is properly prepared, properly signed. One of the things is that it's got to be signed in the presence of the witnesses as well, at the same time in the same place. So you can't say, well, look, I'm signing today as a witness and tomorrow somebody else is signing as a witness. No, they all have to be done together. So once again, thank you very much. Jazakallah khairan. Islamic wills are important. I don't believe that standard Islamic wills are good enough. I think that one needs to get proper advice on every issue. Each person's case is different, and a standard Islamic will doesn't cater for everybody's needs. So in a way, it's good to have one. It must be done, but at the same time, one needs to have good advice as well. So I'm going to ask Sheikh to close this session with a dua, and we hope, inshallah, that all the listeners and viewers out there would have had tremendous benefit out of this, and at least it will start making us think about Islamic wills and estate planning. Jazakallah khairan. Barakallahu feek. Sheikh, over to you.
الفاتحة. بسم الله الرحمن الرحيم. الحمد لله رب العالمين، والصلاة والسلام على أشرف المرسلين سيدنا وحبيبنا ومولانا محمد صلى الله عليه وسلم وعلى آله وصحبه أجمعين. اللهم ربنا تقبل منا إنك أنت السميع العليم، وتب علينا إنك أنت التواب الرحيم، واهدنا ووفقنا إلى الحق وإلى طريق المستقيم ببركة القرآن الكريم. اللهم ربنا زدنا علما وارزقنا فهما، واغفر لنا ذنوبنا وذنوب والدينا ولمشايخنا ولجميع المسلمين أجمعين. يا أيها الذين آمنوا اصبروا وصابروا ورابطوا واتقوا الله لعلكم تفلحون. وتمت كلمة ربك صدقا وعدلا لا مبدل لكلماته وهو السميع العليم. سبحان ربك رب العزة عما يصفون، وسلام على المرسلين، والحمد لله رب العالمين.
Ameen. Jazakallah khairan. Once again, Jazakallah. Thank you to Sheikh Muneer. Thank you to Sister Refqah for your wonderful inputs, and we hope to see you again, inshallah, in the future. And all the viewers out there, we hope to see you also, and please do keep in touch. We hope to keep in touch with you as well. Assalamu alaikum wa rahmatullahi wa barakatuh.
When we take care of each other, wonderful things happen. Children thrive, the elderly rejoice, and communities celebrate. Awqaf South Africa, a charitable Waqf organization, makes it easy to share the care. All donations are ploughed into Sharia-compliant investments, while the fruits support a wide variety of charitable causes. Visit awqafsa.org.za to discover how your Waqf can bless our community with a legacy of care.